For today's United States Supreme Court decision, we deal with the issue of personal jurisdiction. When you are being sued, you have to be sued in a place in which you have sufficient minimum contacts. That case goes all the way back in Civ Pro, as we all learned from our Civ Pro classes. It's a case that is old and understood very well by whole people. International shoe and sort of personal jurisdiction. You have to have sufficient minimum contacts with a place, right? So if you're an individual, you can be sued in the state in which you live. That's a place where you can generally be sued over anything. And then in states in which you have specific contacts, but they have to be sufficiently minimum. In the case of a corporation, you can be sued in the place where your corporate headquarters are located or your primary place of business, which is typically like where your C-suite is located. So many businesses, for example, are formally licensed in Delaware. That's where they're formally incorporated, but not necessarily where their primary offices are. So you can sue them either one. So we're kind of dealing with that issue today. Can we sue a person or a corporation in this particular place? So this deals with that issue of sufficient minimum contacts and what is sufficiently minimum. So let's get started with this. Robert Mallory worked for Norfolk Southern as a freight car mechanic for nearly 20 years, first in Ohio, then in Virginia. He is working on the railroad all the livelong day. The railroad, as one would appreciate, travels through multiple different states. He works in some of those states, including Ohio and Virginia. After he left the company, he moved to Pennsylvania for a period of time before he returned to Virginia. Along the way, he was diagnosed with cancer. Because he attributed his illness to his work, he sued his former employer under the Federal Employers Liability Act. So they're a railroad. As you would expect, railroads are governed by federal law because they travel interstate. They are sort of the original interstate commerce. And so much federal law applies when it deals with the railroads. So he thinks his employer is responsible for the harm he has befallen. He'd like to sue his employer. He'd like to sue them under federal law. Fine. So there is a federal law that provides compensation that permits railroad employees to recover damages for employer's negligence. My employer did it bad. They harmed me. I want compensation for the bad they did. Okie dokie. Critically, for our purposes, he filed suit in Pennsylvania State Court. Pennsylvania State Court. He worked in Ohio. He worked in Virginia, but we're suing in Pennsylvania. All right. He is suing them even though Norfolk Southern is itself incorporated in Virginia and also headquartered there. So those states can be different. They often are different, but they don't necessarily need to be different. As I pointed out, many corporations are incorporated in Delaware, but their corporate headquarters aren't necessarily located in Delaware. So you can sue them either place. But in this particular case, that's the same place. They are incorporated in Virginia. Their primary place of business is Virginia. So it's Virginia or Virginia under international shoe and its subsequent case law. Okie dokie. So we can definitely sue them in Virginia. In fact, the Supreme Court suggests we can only sue them in Virginia. That's the case law up to this moment. But we're suing them in Pennsylvania. All right. So he sues them, and he rested the suit on the basis that Pennsylvania's court exercised a personal jurisdiction over it would offend due process. So the railroad over here is like, this is not fair that we're being sued in Pennsylvania. Under the law as it exists up to this moment, we can only be sued in the place where we are primarily located, Virginia, or the state in which we're incorporated, Virginia. So your choices are Virginia or Virginia. He wants to bring it in Pennsylvania because he has a slightly better cause of action under Pennsylvania law. Pennsylvania law is more attractive to him. So he'd prefer Pennsylvania because the Pennsylvania law is a little bit more favorable to him in this particular situation. The railroad would very much prefer Virginia, and they're like, you literally can't sue us anywhere except Virginia. It would offend due process for us to be sued here. All right. Norfolk Southern noted that when the complaint was filed, the person who's suing resided in Virginia, and the complaint alleged that he was exposed to carcinogens only in Ohio and Virginia. So it isn't even the place of the injury. It isn't even the place of the injury on top of everything else. So first of all, you can only sue us in Virginia. Second of all, if you could sue us somewhere else, because that's the place of the injury, so maybe we have maybe that's enough for a specialized case, then Ohio, sure, because that's where that occurred, but you weren't injured in Virginia. So, or you weren't injured in Pennsylvania, rather. So, why are you suing us in Pennsylvania? Because the law happens to be more attractive there. But what's your basis for saying the injury allows you to be us to be sued there? All right. He points to Norfolk Southern's presence in Pennsylvania, noting that Norfolk Southern manages over 2,000 miles of track, operates 11 rail yards, and runs 3 locomotive repair shops in Pennsylvania. So Norfolk Southern over here, why is it fair you be sued in Pennsylvania? Well, you're sued in Pennsylvania all the time, is sort of the idea. You run a lot of shop in Pennsylvania. So Pennsylvania is a place where you can be generally sued. Uh-oh. Uh-oh. Right? So this is the idea. It's not that I have the specific injury in Pennsylvania. It's the idea of general jurisdiction. So we're flying directly in the face of United States Supreme Court law over here, right? We want to sue a corporation. We can sue them generally where they live. Where does a corporation live? Well, they live in the place of incorporation or the place in which they primarily do business. For this railroad, that's Virginia. So if we want to sue them for anything, Virginia would be fine. If we want to sue them for a specific thing, perhaps where the specific thing occurred. But now we want to say, no, we want to sue you in Pennsylvania. Not because the specific thing occurred in Pennsylvania. Oh, no. But because you are generally located in Pennsylvania. Uh-oh. Because that directly flies in the face of Supreme Court precedent. You can't do that. Or can you? Because we're before the United States Supreme Court. So they're the ones about to decide whether or not this old doctrine remains the law. How exciting. So Norfolk Southern has registered to do business in Pennsylvania in light of its regular, systematic, and extensive operations. Uh-oh, we are directly challenging Supreme Court precedent. We're flying right smack dab in the face of personal jurisdiction precedent over here. Can we sue Norfolk Southern generally in Pennsylvania, despite the fact it's neither incorporated there nor its primary place of business there? The law up to right now would be the answer is no. Does it continue to be no? Pennsylvania requires out-of-state companies that register to do business in Commonwealth to agree to appear in courts on any cause of action. So he's trying to say that by registering in Pennsylvania, they've agreed, essentially by contract, they've agreed to waive this issue. So sure, you couldn't normally be waived and you couldn't normally be sued in Pennsylvania, but by doing business in Pennsylvania, you have waived that issue. Waiver. Okay. Well, you can see the problem right away, right? If states could require waiver, then every state will require waiver and for every kinds of action, and it will completely defeat this. So if we allow Norfolk Southern to be sued in Pennsylvania because they agreed to a waiver that was imposed on them as an operation of law, you know for an absolute certainty that every single state is going to require every single business to agree to these waivers. So the concept of general jurisdiction when it comes to corporations will come to an absolute and total end, and right quick. So if this is the right answer, it is the end of law as we know it. So, there's that. Okay. By complying with the statutory scheme, the person who's harmed over here submits that Norfolk Southern has consented to suit. If that's true, it's the end of the issue when it comes to general jurisdiction for corporations, because they will be generally sued everywhere, because every single state will require that they waive it. You know for certainty it will happen. So, do we want to do this? I'm betting the Supreme Court's going to say no. I'm betting the Supreme Court's going to say no. I'm going to say that no, Pennsylvania cannot require them to waive this as a matter of statutory agreement, because it would impose an unfair condition in the regulation of interstate commerce. So I'm betting the Supreme Court is going to stand by the precedent and say, no, you can't do this. Let's find out if I'm right. The Pennsylvania Supreme Court sided with Norfolk Southern because the Pennsylvania Supreme Court is bound by the law. And so, sure, the Pennsylvania Supreme Court should side with Norfolk Southern because that is absolutely the correct answer up until right now. So the Pennsylvania Supreme Court came to the right decision under the precedent. Only one place left to go. Change the precedent, right? So let's see if we can do that. That court have found that Pennsylvania law requiring the out-of-state firm to answer in the Commonwealth for any suits against it in exchange for status as a registered foreign corporation violates due process. The Pennsylvania Supreme Court is right. Let's find out if it continues to be right. Held. The judgment is vacated and the case remanded. Ooh. Personal jurisdiction looks like it might be changing. Okay, so it looks like we're about to change the law when it comes to corporation. Every corporation's ears perk up like, wait, what now? Wait, what now? What's going on? All right, let's find out. This case is controlled by Pennsylvania Fire versus Gold Issue Mining. Much like the Missouri law that the court in Pennsylvania Fire found to comport with due process clause, the Pennsylvania law issue here provides that out-of-state corporations may not do business in the state unless it registers with the Department of State. Ooh, okay, guys. Big changes coming down. Big changes coming down here at Supreme Court land. It's going to hit you like a freight train. It's coming down so hard. Okay. Among other things, Pennsylvania law is explicit that qualifications as a foreign corporation shall permit state courts to exercise general personal jurisdiction over registered foreign corporations, just as they can over domestic corporations. Ooh. Norfolk Southern has complied with this law since 1998 when it registered to do business in Pennsylvania. Norfolk Southern applied for a certificate of authority from Commonwealth, which, once approved, conferred on Norfolk Southern both benefits and burdens shared by domestic corporations, including amenability to suit in state court on any claim. For more than 2 decades, Norfolk Southern has agreed to be found in Pennsylvania and answer any suit there. Holy shit, dude. This feels like one hell of a change in the law. This feels like one hell of a change in the law, because up to this second, the answer for general personal jurisdiction was the state of incorporation and the state of your principal place of business, period. End of analysis. Those 2 places, no other places. And they could be the same place, as I point out. So no more than 2 places. And the U.S. Supreme Court just said, okay, states can waive that by imposing on you as a condition of law. So we went from businesses can only be sued in Delaware. We went from businesses can only be sued in Delaware to suddenly businesses can be sued everywhere. Okay. I mean, sure, that's a pretty big change in the law. That's a pretty big change in the law. So, okay. All right. Pennsylvania Fire held suits premised on these grounds do not defy defendants' due process. Mr. Mallory no longer lives in Pennsylvania, and the cause of action did not accrue there, but none of that makes any difference. Wow. To decide this case, the court need not speculate whether any other statutory scheme and set of facts will establish consent. It's enough to acknowledge the state law and facts before it falls squarely within Pennsylvania Fire. Okay. In proceedings below, the Pennsylvania Supreme Court seemed to recognize Pennsylvania Fire dictated an answer, but ruled for Norfolk Southern because, in its view, intervening decisions had implicitly overruled Pennsylvania Fire. Yeah, the Supreme Court says that's an error. Was it? Was it an error? I guess it was. Because, well, I apparently came to the wrong conclusion along with literally everyone else. Yeah, we all were under the impression that that old law was no longer good law. But apparently it's good law, I guess. As the court has explained, if a precedent of the court has direct application in the case, as Pennsylvania Fire does, a lower court should follow the case which directly controls, leading to this court the prerogative of overruling its own decision. This is true even if the lower court thinks the precedent is in tension with some other lines of decision. Yeah, intention would be one way of describing it. Yeah, vacated and remanded. Okay, okie dokie. Thus, that brings us to the end of discussion of Mallory versus Norfolk Southern, and holy shit, this is a huge issue. This is a really, really big deal. Personal jurisdiction law just changed in a super major way, in an incredibly major way, in a 5-4 decision. Up until like 5 seconds ago, if you wanted to sue a corporation generally, you could only sue it in the place where it was incorporated and the place of its primary business, which is typically its C-suite, where its top executives are. That's typically how you define that. Only those two places generally. Maybe you can sue it specifically over specific things that occurred specifically in other states, but this is not that. This has nothing to do with Pennsylvania. Literally has nothing to do with Pennsylvania. Okay, the injury didn't occur in Pennsylvania. No one's suggesting it occurred in Pennsylvania. Mallory has no ties to Pennsylvania. He briefly lived there, but that has nothing to do with anything. Okay, so this has nothing to do with Pennsylvania at all. But we're going to sue in Pennsylvania. Why? Because the law is slightly more attractive in Pennsylvania than it is in Virginia or Ohio. We could sue in those places, but we don't want to. We want to sue in Pennsylvania because the law is more attractive there. And apparently we can. Apparently we can, because state law can require a corporation to consent to general personal jurisdiction as a condition for doing business in the state. And apparently that's not a problem. So interstate commerce just became a lot more complicated for every single corporation in the face of existence. Holy shit, guys. I'm not sure if I'm selling how big a deal this is. This is a really, really big deal. This is an incredibly big deal. And it's a 5-4 decision, and I'm not surprised because this is a major, major modification of the understanding of personal jurisdiction law. And yeah, so there's that. And that for the moment brings us to the end of discussion of this state.